Hi, my name is Kim Mutcherson, co-dean of Rutgers Law School in Camden, and this is The Power of Attorney.
I'm very excited to be here today with one of my senior colleagues, Mike Carrier. So thank you so much for being on the podcast, Mike.
Thanks for having me, Kim.
Absolutely. I'm so excited to talk to you. So let's give people a little bit of background before we get into the meat of the incredibly interesting things that you've been doing from your perch as a law professor. So first of all, tell us how long you've been here at Rutgers Law School.
I've been here since the year 2000.
All right. So this has been the bulk of your career, basically.
Yes.
Excellent. And how did you end up becoming a law professor? All the different things that you could have done with a law degree, and here you are.
I had a sense that I loved to write. So when I was in law school, I wrote a law review note on the recess appointments clause that I really took a real interest in, and found myself thinking about antitrust. I had taken a class in antitrust that really changed my life, and wanting to write in a more detailed and focused fashion than I could in the law firm. I practiced law in DC for 4 years. I loved it, but I found myself really wanting to have more time and space to write.
So you just said something that my guess is a lot of people have not experienced, which is you took a class in antitrust and it changed your life. So tell me a little bit about that. What was it about that class?
In my first year, I was fortunate to take a class with Professor Tom Kuiper, who headed the antitrust division in the 1970s, was responsible for the breakup of AT&T. And in my second year of law school, I decided to take classes based on the professor, figuring that I could take whatever I needed before I graduated, but I really wanted to be interested and passionate about the material. And so I took antitrust in my second year of law school, which not a lot of people do, and it did change my life. It really was such a fascinating class, hearing about the heading of the antitrust division, the breaking up of AT&T, that I found myself reading antitrust for fun. And so I was down in the bowels of the law library, and instead of doing my reading for work, I would pick up an antitrust journal. Never said I was normal, but nonetheless, it showed that this was something I really wanted to do.
And for folks who might not be sort of steeped in the law, or certainly not steeped in the law of antitrust, can you just describe what is antitrust about and why does it matter?
Antitrust is about promoting competition. So usually the markets work the way that they should, but sometimes they don't. Sometimes competitors get together and they collude to increase price. Sometimes monopolists take action that only makes sense by hurting rivals. Sometimes you get big tech companies that politicians say need to be broken up. And so there really are a lot of fun things going on in antitrust these days.
Mm-hmm. So you went to the firm, did some work there, and then decided that you wanted to be a law professor, in large part because you wanted to have the opportunity to write. And we're definitely going to talk about writing. But I also want to talk about teaching and just sort of being in a classroom. So I think one of the things that I would like to think we can pride ourselves on at Rutgers Law is that we have some really amazing people in our classrooms, and I would count you among that group of folks. So can you talk a little bit about what is it that you're trying to achieve when you're in a classroom, right? I think people often have a very particular vision of what a law school classroom is like, and that it is not a fun place to learn, but I don't think that's always true. So I'd love to hear you talk about, what's important about teaching to you, and what are the things that you do in teaching that you think are particularly effective for law students?
I think it's so much fun to learn with students what the law is, to think about the policy implications of the law, to think about how all of this is so timely and relevant today. Areas of antitrust, intellectual property really are on the front pages of the paper. And so I really take pride in working with students to have the light bulbs click on, to learn what the law is, and to think about different sides of an issue. I use the Socratic method. I tell the students it's not to embarrass them, it's to get everyone involved. That once you participate, you think about things in a different way. And these are just such fascinating issues that I'm so excited to spend my time with the students thinking about the issues.
Yeah, I think one of the things that students can definitely pick up on is whether you're teaching material that you're actually interested in, right? And when you're interested in the material, it creates this sort of, infectious spirit in the classroom, which is really nice.
It's really so fortunate that I love what I do, and that everything I do on the scholarship side, I try to bring into the classroom. So the students get to see what's going on in Congress and the courts and the agencies. And I feel passionate about making a difference. I think the law can be used to make a difference. And I just want to share that with the students.
Well, let me actually go backwards a little bit then. People have all sorts of different reasons why they go to law school, all sorts of different reasons why, the law appeals to them. And I always think it's interesting to sort of hear about, most people's stories are not just, I was an English major and couldn't go to medical school, and so I ended up in law school, right? Like, I like to think that there's a deeper reason behind it. So why law school?
Law really can make a difference in society. With all that's going on in the world, especially in the past few years, there has been a sense in which law is the ultimate backdrop that will protect us, that whatever chaos is going on in the world, we always can rely on the law. And when you get a law degree, you're giving yourself a special tool that helps you not only as a lawyer, but in your society, in life, in going to the local county board meeting, in thinking about how arguments work. The law really is a powerful tool that you can use wherever you go in society.
Absolutely. All right, so now I want to talk about the really, really interesting work that you've been doing for several years now. So sometimes I think the vision that people have of law professors is a bunch of people, sitting around in our ivory towers just talking to each other, writing law review articles that only other law professors and our parents read. And yet you are one of those people who I would definitely put into the category of folks who I refer to as academic activists, right? So people who are using this opportunity and this platform to have a significant impact on the world. So let's talk about that a little bit. So one, I want to just get into what the work is that you're doing. What's the thing that has ignited you and what the problem is that you've identified. And then we can kind of talk about the work that you've been doing to try to fix that problem.
Sure. So the big picture issue is drug pricing. Drug prices are too high, and the question is, what should we do about them? Mm-hmm. So I have focused from the antitrust angle on all sorts of activity that drug companies have engaged in. Brand companies have paid generics to stay off the market. They've engaged in product hopping, switching from one version of a drug to another. They filed frivolous citizen petitions with the FDA. They've denied samples that generics need. And in all of these examples, they're taking activity and doing it when there's no reason at all, based on innovation or patents, and all it does is increase drug pricing. And so I've tried to use antitrust law to show the problems with that and how we can fix it.
Mm-hmm. So again, to give people a little bit of background, let's talk a little bit about how big pharma works, right? So we have these people, these companies that are developing new drugs. They will tell you that every drug costs billions of dollars, right, in order to create it as they go through the whole process. And then sort of as a reward for the work that they're doing, they get a certain period of time where they're the only ones who can sell that drug, right? Okay, so fill in all the little spaces that I just did not fill in the explanation I just gave.
So that is certainly where we begin. So it is very difficult to create a drug that reaches the market. Out of every 5,000 compounds that are investigated, one will reach the market. It takes a long period of time. Pharma companies say it takes billions of dollars. I'm not sure if that's true. Mm-hmm. We don't get to see the figures, right. But nonetheless, it does take a long time. And certainly they are entitled to reap the rewards when they have valid patents. The problem is that sometimes they're not exactly doing what the patent system had in mind. They're not doing what Congress had in mind when they passed legislation called the Hatch-Waxman Act that had a significant purpose of promoting generic competition. They're playing games with state substitution laws that allow a pharmacy to switch a generic version for a brand version. So there is something to be said for the story about innovation, but on the other hand, there are a lot of other stories to be told as well.
Mm-hmm. So first, tell people what a patent does, right? And why it's so important in this particular context.
A patent gives you a 20-year right of exclusion, by which you can exclude all your other competitors from the market for a 20-year period. And the reason why we have patents, the reason why we have intellectual property in general, is to encourage innovation. And the thought is, if we don't give you this right to exclude, then you wouldn't innovate. That's not good for society. And so that's why we have patents.
So we have patents, and the sort of core purpose of patents is to get companies to continue to do new things, right? There's nothing interesting about people doing the same thing over and over again. And innovation also, particularly in this context, innovation potentially saves lives, right? And so this is definitely a space where we want to be able to promote that. And yet, I think that your position would be that the patent system is not working properly in this context. So what's wrong with it?
So you're right. We do have to make sure that true innovation is rewarded. On the other hand, sometimes patents are used in a way that does not promote innovation. So Humira is a drug that treats rheumatoid arthritis. There are 136 patents that cover Humira. And the important patents, the ones that cover the active ingredient of the drug, that expired years ago. But in the couple years before that active ingredient patent expired, the company AbbVie got more than 50 patents. So are you telling me that all 136 patents really were needed for innovation? Or was this part of what they were doing in terms of building a portfolio to keep competitors off the market? Another example is insulin. So Lantus treats insulin. There are 74 patents on Lantus, 95% of which were obtained after Lantus was on the market. Are you telling me that all 70 of those patents were crucial for innovation? Sure, they keep competitors off the market. They have very little to do with innovation.
So then, of course, the question becomes, who's at fault for this, right? So we have the patent office. So somebody is making decisions to allow these patents to happen. My guess is that if I went out on the street, there'd be a bunch of people who said lawyers are the problem here, right? So when a company says, we want to be the only people who can sell this for a very long time, they've got a lawyer on hand who's helping them do that process. And then I would assume that another piece of that is going to be Congress, right? That's who could really step in and change this system, and they have chosen not to enforce the statutes that would allow us to change this system. So what are the different levers here?
There are so many different levers, and big picture response, that's what I love about this. It's incredibly complicated. There are so many places to improve the system, and we think about the pros and cons for each. So as you mentioned, you have the patent system. There are lots of patents being awarded that should not be awarded. You also have the FDA, the Food and Drug Administration, is deciding what should be on the market. Usually the standard is pretty low. Is it good compared to a placebo as opposed to what's already on the market? Then you have the insurance companies and the PBMs, the pharmacy benefit managers, that are supposed to be putting on the formulary the drugs that are most effective and cheapest, but they get payouts from brand companies in the form of rebates, so they put brand drugs higher than generics on the formularies. There is so much going on, and you can tweak every part of the system to improve it.
Who's doing the tweaking? Or is nobody doing the tweaking?
So I'm hopeful that Congress will do some tweaking. So there's been a lot of attention this year on drug pricing. I feel sometimes like drug pricing is the one truly bipartisan issue in DC these days. When senators from both parties go home and hear from their outraged constituents that they can't afford their drugs. And whatever you say about innovation, it doesn't work if consumers can't afford it and people are not taking their medication and even dying because they can't afford it. And so I think that Congress is taking this very seriously. There are tons of pieces of legislation that have moved pretty far along the process this year, and there's a lot that can be done.
Are there particular pieces of legislation that you are paying attention to that you think would have a real impact here?
Yes, I think that a lot of the antitrust legislation could. So one involves pay-for-delay settlements. The Supreme Court 6 years ago in a case called FTC v. Activists found that these agreements could violate the antitrust laws. Nonetheless, some courts have ignored that decision. It's really hard for the FTC to show that a $50 million payment is for delayed entry as compared to generic services. That gets pretty nuanced. And so there's legislation on settlements that Congress could adopt. The same goes for product hopping, switching from one version of a drug to another. Senator John Cornyn from Texas worked with Senator Blumenthal from Connecticut on a bill on product hopping that would allow the FTC to go after some of these ludicrous switches, or the denial of samples. So there's something called REMS, risk evaluation mitigation strategies, where if the FDA says the drug is unsafe, then you need special permission. And the brand companies have used this to keep the generic off the market by saying, I'm not going to share my sample with you, even if the generic shares a letter from the FDA where the FDA says we have no safety concern. And so that's something called the CREATES Act that Congress could act on. So those are just 3 pieces of legislation that I think could make a difference.
Mm-hmm. So the cynic in me has to respond to that with, Congress doesn't seem to be doing much of anything useful these days, right? It just seems like people are screaming at each other and politics have just sunk into a new low. So do you really think that there's good stuff on the horizon here?
Absolutely. And all that antitrust legislation that I mentioned has bipartisan support. Some of it passed out of the House Energy and Commerce Committee 53-0. Some of it was unanimously adopted by the Senate Judiciary Committee. I have spoken to Republican and Democratic staffers, and Republican senators are just as excited about this as Democratic senators. The difficulty here is that there are a lot of moving pieces, and some of those pieces are more partisan than others. So once you talk about Medicare and negotiation of pricing, all of a sudden it becomes partisan. And what could have been a unanimous vote in the House of Representatives in favor of some of this antitrust legislation becomes a 220 to 190 vote because Republicans don't support it. And so it's an interesting question as to how any legislation would get through Congress, if it's just the bipartisan antitrust stuff that I mentioned, or if there's anything else.
Mm-hmm. So I want to get to the academic activist part of this, because every time I look up, you're down in DC and you're testifying in front of Congress and you're talking to all these different folks. So can you talk to us about that work a little bit? So one, sort of how you became this really powerful, I think, voice talking about these issues, and then how you leverage what you do as a law professor in order to be able to hopefully affect change in DC.
One of the benefits of being a law professor is that you can go as deeply as anyone in the world. And so when you're a practicing lawyer, you don't have time to do that. There are client demands, there are litigation deadlines, so you can't always explore problems in that level of detail. I wrote a book a decade ago in which I looked at innovation in antitrust and intellectual property. And for that, I discovered the pharmaceutical industry, which is something that I had not been in a rush to learn about because it is so complicated. It's patent law, it's antitrust law, it's federal law, the Hatch-Waxman Act, it's state substitution laws, it's interesting markets. So it really is complicated. So I took a month or two to really dive into it, said something about pay for delay settlements, and have stuck around in the pharmaceutical area because there's a lot going on. Big Pharma has a lot at stake and has a lot of interest in promoting what they call life cycle management, what I call anti-competitive conduct. and so there's
Tomato.
That's right. And so there's always something to do there. And what I've tried to do is a balance between big framework shifting articles, here's how we should look at product hopping, for example, versus shorter pieces. Here are 5 things Congress can do about citizen petitions. I'm in touch with various offices. I share my proposals. And I try to write in a way that Congress and the courts can use it. And that's not always the case in academia. Sometimes our heads get high up in the clouds and we forget where the ground is. But I think we owe the institutions our expertise and being able to share it in a form that they can use it.
Just really quickly, can you explain to folks what a citizen petition is so that they understand why this matters?
Sure. A citizen petition is a petition filed with the FDA to raise safety concerns with a drug. And in theory, that makes a lot of sense. You're giving a citizen the power to go to the FDA to say there's a problem here, and that sounds great. But I did a couple of empirical studies with former students who were excellent co-authors, and we discovered that just about all these petitions are filed by brand companies, and the FDA denies just about all of them. And so really you ask, well, why are these things being filed? And the answer is to keep generics off the market.
So I want to talk a little bit about sort of the bigger picture sort of politics and complication of all of this. On one hand, we have so much division about healthcare, and it's very clear that that's deeply partisan. People are definitely on very different sides of the aisle about that. And this seems like it should fall into the same category in some way. And yet it's this weird kind of carved out space. And I'm trying to sort of wrap my head around why that is, right? I mean, the person who has diabetes and needs insulin, they need insulin, but they also need a whole bunch of other things related to healthcare. So how is it that we're allowing these things to be separate as opposed to seeing them all in the same box?
Well, it's relative. So a few years ago, there was not such consensus behind this antitrust legislation. I think at some point the issue of drug pricing became so obviously a problem that even Congress said we have to do something about this. And I think of the menu of options, antitrust really is the least intrusive option. And so when I testify, oftentimes Democratic and Republican senators and representatives say, well, we don't want to touch innovation. And I say, I'm not touching your innovation. There are other potential remedies out there that could affect innovation if you require the price to be really low, or if you have compulsory licensing. Compulsory licensing is when you're forcing a drug company to share the drug, maybe because the price is too high and people are not accessing it.
Right.
And
sometimes compulsory licensing is used in the context of some sort of significant public health emergency, and you want to make sure that people have access to medication.
Exactly. So after the anthrax attacks in 2001, there was a threat that Cipro would be forced to share its antibiotics. And once that threat was made, Cipro said, okay, we're going to lower the price. And so usually it does work as a threat. But I come in and I say, I'm just going after the bad apples. And most of the time there are settlements that don't involve payment. There are reformulations that don't involve product hopping. And by focusing on the bad actors, I don't mean to discount everyone else that's doing great work all the time. I mean, again, drug companies serve so many valuable purposes that our society depends on. But for the bad apples, I think it's a no-brainer because you can have your cake and eat it too. You can have all the innovation without the games, which really would help all of us.
So I want to talk about drug pricing, because it feels to me like this is just like in healthcare where it's so opaque. You know, you go into the hospital and then you come out and you're like, why do they charge me $500 for a Q-tip, right? And just trying to make sense of that. And I think it's the same thing in the context of big pharma. So on one hand, you know, I think about if you're a person who has chronic illnesses and you're getting medications every month and you're paying $15 and you look at what your insurance company is paying and it's like $1,000. Right. How do we make sense of that? And is part of what's happening here that drug companies are, because it's so opaque, they just set whatever price they want to, and we have no way of understanding where those numbers are coming from, and certainly no way of controlling in most cases what those numbers are. So how are they getting these prices?
They price it at whatever level they can get away with. And sometimes these drugs are off patent. They're not recovering innovation costs, but they can get away with it. They have a monopoly, and so that's what they do. It is such a unique system in which there really is no other industry with what I call the price disconnect, and the FTC is called the price disconnect, because you don't have one single actor that's deciding whether an increase in quality is worth an increase in price. You go into the store and there are two kinds of paper clips, and one is an improvement on the other. It's 10% improvement because 50% more. You can make that price quality determination as to whether it's worth buying the better paperclip. You can't do that in the pharmaceutical industry because there isn't one actor that makes that determination. It's the consumer or insurance company that pays for it. It's the doctor that prescribes it. And in all of this complication, there are room for anti-competitive games. And so that's what happens. Then you have everyone blaming everyone else in the system. So the drug companies say it's not our fault, it's the PBMs, the pharmacy benefit managers. The PBMs say we're not setting the price, the drug companies are. And in the past, I thought that was a way for everyone to evade responsibility. Now I think it's actually a way for something to get done because it's more, there's more than one bad actor here. And so maybe that opens the door to do something.
What would you say to people whose response to, everything that you're saying, that sounds very reasonable, respond with Big Pharma's business? Their job is not to make sure that everybody gets all the medications that they want. Their job is to make money for themselves and for their shareholders. And why should we interfere with their business practices, as long as they're doing what their company was created to do.
It's not just about rewarding shareholders. Leaving aside the fact that maybe drug companies should do something other than promoting their bottom line, like maybe helping all of us in society, there's a difference between reaping the rewards from earned innovation and gaming the system where it doesn't promote innovation at all and it only consists of keeping generics off the market. And so why should a brand company pay $100 million for the generic to delay entering the market? It could rely on its patent to keep the generic away for some of the time, but why pay $100 million on top of that to keep it away for more of the time? And that pay for delay settlement story is a tough one because the brand companies and the settling generics both do well. And the shareholders love it. And the generics industry actually is more in favor of these pay-for-delay settlements than the brand company is. California just passed legislation. At the end of the day, Big Pharma signed off on it. The generics industry did not. And so certainly this is in the shareholders' interest, but someone is left holding the bag. And that person is the American consumer who's forced to spend billions of dollars more than they need to.
Right. What you just said also made me think a little bit about where the solutions might come from. So you've been very focused on Congress. Is this something where individual states have been or could be taking steps to try to make, at least for the folks within their borders, make life a little better for them and their access to medication a little bit better?
Yes. So California just passed the first pay-for-delay legislation that is designed to stop this behavior by which brands pay generics to stay off the market. Other states have passed transparency legislation. One of the problems here is we don't know what's going on. So let's figure out how much R&D is actually going down. Let's figure out...
R&D means research and development.
Thank you. I couldn't have done this without you, Kim. And let's see what's going on because the system is so opaque that leads to all sorts of anti-competitive harms. And so if we shine some light on the problem, that could help. And states are starting to do that.
One of the other things that some pharmaceutical companies do is these sort of compassionate programs where they'll say, if you're taking X medication and you can't afford it, well, then we'll provide it for you or we'll provide it, at less cost for you. Is there any sense in which that is actually a way to maybe get some of the outcomes that you are looking for? Or is it just that all of that is on such a small scale that it almost is too much of a drop in the bucket?
My sense is it's on a small scale. And it is a public relations ploy. It's a way to get the press off their back. So the EpiPen had a $600 price tag. And so Mylan said, we'll introduce our own authorized generic for $300. So $300 sounds better than $600. But if a true generic was on the market, the price would be a lot less than that. And so my sense is that this is a way to deflect some of the negative press that they're getting while still not getting to the root of the problem.
It also seems to me that part of the conversation that swirls here, which is interesting just in terms of consumers, is because there's so much targeting of consumers now, right? I mean, if you're sitting and watching television, you are seeing ads that are telling you to ask your doctor about this medication and that medication. And part of what I think that does is it makes people think that brand names are really important. So that generics are this sort of knockoff opportunity as opposed to being able to take the real pill. And my guess is some of that is Big Pharma creating that sense out in the world.
Absolutely. When you have direct to consumer advertising, you have that effect. And the US and New Zealand are the only two countries in the world that allow this to happen. It doesn't make
Wait, the US and New Zealand are the only countries that allow direct to consumer advertising?
Yes.
Wow.
Yes. And so you wonder why this is the case, that we are allowing this. And it does affect consumers who go to their doctor. They say, we heard good things about the brands. And it doesn't make a lot of sense to do that. Nonetheless, that's what we have.
Right. I also wanted to ask you about how distinct pharma is. So it seems like some of the solutions that we're talking about, and I don't know these bills that are moving through Congress well enough, but to the extent that they are really targeting pharma, I wonder if there are other industries or lessons for other industries that could or should be learned from what you and others are trying to do in the context of Big Pharma. What are the lessons we should be learning here?
I think some of the lessons are specific to the pharmaceutical industry because there's no other industry where Congress has passed a law that says generic competition and low prices are essential to the system that we have. And so there are a lot of unique aspects to the pharmaceutical industry. That being said, it's an exciting time to practice antitrust law and to think about antitrust law. And just a couple days ago, for the antitrust panel here, where several respected antitrust attorneys came and spoke to students, 60 to 70 students showed up at 6 o'clock at night, and I was blown away by the level of interest in antitrust law these days, which I have not seen before. When you talk about these big companies, there's a sense that they have a lot of power. And that Facebook and Google and Amazon maybe have control over our lives in a way that is not comfortable. And so this sense of big companies with a lot of power is something that has tapped a lot of people on the individual level and on the level of DC.
Yeah. And I think it also feels like they're in our homes more in some ways. And I think that that's a piece of what makes people really nervous now in ways that they might not have been in the past.
Exactly. They are following everything that you're doing, where you're going, the websites you're searching. You're getting ads based on where you've clicked or even what you've thought or even what you've said. And so it is a bit scary. And the question is, what do we do with it? I don't think there's a simple answer, but there really are important issues.
So one of the things that I think is really fascinating, and almost in any area of law that you're working in, is sort of watching how technology and advancements in science and tech change how we think about things or make things harder or require us to, the internet forces us to think differently about free speech, right? So I wonder if you can talk a little bit about what are some of the shifts in technology and the ways that technology is a part of our lives that have impacted antitrust law as a whole.
The interesting thing about tech is it changes the way that we think. So you look at the generation behind us. I have a couple of daughters in high school. They process the world differently than the way that we do. They have access to all the information they could ever want at the click of a button. And I sometimes try to stay away from all this during the day when I get to the deep thinking that you can't do when all those buttons are around. And so that's a tough lesson to try to share. Nonetheless, we do have everything at our fingertips. We have all the information we want through Google. We have all of our friends goings on Facebook. We have packages that show up on our doorstep 5 seconds after we order them through Amazon. So we have all of this convenience, but what are we giving up? And maybe we're giving up some privacy because we can be tracked more easily. Maybe we're giving up on a deeper level, a different way of thinking about the world, a way that is more reflective and not so reactive to all those dings on our phone.
So my last question, I guess it's actually sort of two questions. So the first part of the question is what's next, right? What's up for you next in terms of the work that you're doing? Like, are you going back down to DC? Are you writing something? And then the second question is, what's the legacy that you're looking for, right? I mean, you're doing all of this amazing work, as I said, that has the potential to be, frankly, life-changing and world-shifting, but really, really big things. So like when people look back on the career of Mike Carrier, what do you want them to be thinking about? What do you want to have achieved? So one, what's next? And then two, what's the legacy?
So on the first point, there's always something to fight against. And so the Supreme Court and FTC v. activists said that it could violate the antitrust laws when a brand company pays a generic to stay off the market. So keeping that legacy is akin to Sisyphus, where the rock is always coming down the mountain. And I recently wrote an article on this, where there's always that rock coming down the mountain when the settling parties and the drug companies have every interest to try to muddy the waters and to say there's entry a year before the end of the patent term, so therefore that's a good thing. A generalist judge that sees this case for the first time doesn't know that that argument was foreclosed. And so the FTC, in a case involving impacts, in a 5-0 decision that was written by a Republican-appointed commissioner, ruled that this is all a violation. The settling parties, Impacts in particular, has petitioned to the Fifth Circuit to try to overturn this analysis and basically immunize drug companies for whatever they're doing. So when something like that happens, I spend 5 seconds thinking I have too much work and can't take it on. And then in second 6 going forward for the next couple months, I write an amicus brief, a friend of the court brief on behalf of, in the past, 50 to 70 professors, where I indicate all of the concerns with following the drug companies' arguments, because these are really complicated issues, and the stuff that they say on their face sounds like it makes sense. And so I view my role here as taking my expertise, putting it in plain English, and telling the court why you can't follow the drug companies. And that's part of the bigger legacy. So I have always prided myself on not following the crowd, and that is in part leads to fighting some battles against some pretty big entities. So right now, we've talked a lot about the pharmaceutical industry. I also have an ongoing debate with the head of the Antitrust division, Makin Delrahim. A few years ago, I took on the music industry with copyright and innovation, saying that it's not really helping innovation when you're suing everyone left and right for copyright infringement. And so I guess the unifying theme is the fact that you can take on all of these big actors and use the power of law and hope to make a difference.
I love that. I also love that you're just like, the bigger the target, the more exciting it is to go after them.
About a decade ago, I interviewed 30 CEOs, VPs, venture capitalists about what happened after the Napster decision. Napster's P2P, peer-to-peer, which is trading files directly. And the court said that that was illegal. And my sense, which was backed up by all my interviews, is that innovation stopped as a result. In the last couple of years, we've gotten Spotify and a lot more going on, but there was a long period of time when we didn't have it. And what I saw there was that these really big companies had a lot of reasons not to change, not to upset the apple cart. They're really big. There are a lot of threats. Here you have statutory damages, $150,000 for each copyrighted work, personal liability. The people I was interviewing were being threatened that you're not going to afford your kids' college educations. And so I just wanted to expose all of that. Just because you're big doesn't mean you can get away with it.
Right, absolutely. Thank you so much for taking the time to talk to us, Mike. This was really fun and really fascinating, and I hope that you continue to have the energy to do the amazing stuff that you're doing.
Thanks, Kim, so much. I appreciate it.
Absolutely.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal small campus experience. Learn more by visiting law.rutgers.edu.